Now, I welcome everybody to this discussion of the new tort of serious invasion of privacy. Now, could I start by acknowledging the traditional custodians of the land on which we meet today, the Gadigal people of the Eora Nation. I pay my respects to their elders, past, present and emerging, and extend respect to Aboriginal people and Torres Strait Islanders present here today. Could I start by introducing the panel that we have here today to discuss this interesting topic? Could I start by, we'll do this in seniority, I think. I'll start by directing you to Matthew Lewis. He's a member of these chambers. He's senior counsel specialising in commercial, media, defamation, privacy and administrative law. He also maintains a significant international practice acting in disputes relating to human rights, privacy, media and defamation law. In 2024, he was recognised by his peers in New South Wales as a leading counsel in technology, media and telecommunications law. To my right, immediate right, I have Monique Cowden, who is an experienced advocate with a practice focusing on commercial, equity, public and defamation law. She often appears in class actions for both plaintiffs and funders, and also as an independent advisor to lead plaintiffs on cost issues. In a media practice, Monique routinely appears for journalists and media organisations as well as social media platforms. Since 2022, she's been recognised as recommended and leading junior counsel in technology, media and telecommunications law. She's also a member of the New South Wales Bar Association's Media Information Law and Technology Committee, on which we both serve, and has lectured in defamation law at University of Sydney. To my immediate right is Tim Senior. Tim is a leading specialist in media law, including defamation and privacy. In addition to his media work, Tim practices in areas including intentional torts, such as false imprisonment, malicious prosecution, and has wide experience in commercial litigation. Like each of our speakers, Tim has been recognised by his peers as a preeminent technology, media and telecommunications junior counsel in New South Wales, and currently holds that title, the preeminent man. To my right, and to the right of Monique, is Amanda Sapienza. She has extensive experience in public law and statutory interpretation and has a growing practice in the prosecution and defence of regulatory offences. She's appeared in the High Court, the Full Court, the Federal Court, the New South Wales Court of Appeal, New South Wales Court of Criminal Appeal, Federal Court, New South Wales Supreme Court, and in other courts and tribunals. I'm sure she's been recognised in a number of fields, but certainly in relation to administrative law, she's been recognised as one of the leading practitioners in the area. Moderating tonight is our academic member of Chambers, Professor David Rolph. I'm sure he's well known to just about everybody who draws breath. He's a Professor of Law at the University of Sydney. He's the author of several books, including Reputation, Celebrity and Defamation Law, Contempt. Need I go on? There are so many of them.
Privacy forthcoming.
Privacy. Privacy. We're going to have a debate about this. Privacy forthcoming. This is the Australian law after all. His research has been cited by the High Court of Australia, New South Wales Court of Appeal and the Supreme Courts of Queensland, including recently, South Australia, Western Australia and Victoria. Professor Rolph, he's a member of the Defamation Expert Panel advising the New South Wales Department of Communities and Justice on reforms to the model defamation provisions. As for me, you can just Google me. I've been around for a while. I will hand over to Professor Rolph.
Excellent. All right, so we've got a shiny new tort of invasion of privacy coming on stream quite soon, very soon. So we've got a very eminent panel tonight to discuss a large range of material. We've got a lot of material to traverse. Questions by Slido, so the number that you need to know is 39171119. And we'll be taking those questions at the end after we've heard in turn from each of our speakers. So I might start off with some of the basics. So I'll throw to Mash. So we are going to have this shiny new statutory cause of action for serious invasion of privacy very soon. So let's start with the elements of the cause of action. What are they?
Well, to begin at the beginning, I've called this a mashup of international privacy law. I'm sorry, I'm going to call it privacy. It's my British roots. But it's really a mashup of what's happened in the US or certain states in the US, Canada, New Zealand, as well as the United Kingdom. The elements are five. The first two dot points are really related. So the first dot point is there has to be an intrusion into seclusion. I'll come on to what that means in a minute. But this is a specific US tort which is being picked up in Canada and New Zealand. It's not picked up in UK law. I'll come on to that in a minute. The second element of the cause of action is expressed in the alternative, which is misuse of information that relates to the plaintiff. Again, this is emanating from a US-based tort from the 1960s. It's been predominantly relied on in the UK. You might have heard of misuse of private information. That's the tort which is now operating probably de rigueur in the UK, and it's also been picked up in Canada. Then there's there has to be a reasonable expectation of privacy. Well, that's a straight up UK aspect, and also picked up in New Zealand. Although later authorities might be sort of walking back ever so slightly from that, but it predominantly still exists in New Zealand. And then there has to be an invasion which was intentional or reckless. Now that's interestingly not picked up in the UK. It is a US-based aspect of the tort, and you won't find it in specifically in the UK, but you will find it in Canada. I should have actually added in. It's picked up in Canada too. The invasion then has to be a serious one. We'll come on to what that means in a minute. But those of you who practice in defamation law will probably be familiar with the new threshold of seriousness or serious harm. Something like that will apply in relation to privacy. And then finally, there's this balancing exercise between someone's right to privacy on the one hand and a countervailing public interest on the other. So that really completes the elements of the cause of action in a global sense. So,
do you want to tell us something more about these concepts of misuse of private information and intrusion upon seclusion? So,
I would love to, David.
Excellent. And how they overlap or interact.
Yes, I'm glad you asked.
Thank you, Minister.
Can you tell this might have been rehearsed? In intrusion into seclusion is quintessentially a US-based law. You might have heard of Professor Prosser. Professor Prosser in the 1960s published an article in the California Law Review, and he grouped the different kinds of privacy-related torts into four. Intrusion into seclusion is one, and then there's publication of private facts is another, and then there's misappropriation of likeness, and then there's false light tort. Now, predominantly across the common law world, you'll get protection over the first two, intrusion into seclusion and publication of private facts. So what this tort is doing in Australia is picking up the American aspect of things. The definition of intrusion into seclusion is in section 6 to schedule 2, and it's given a very specific definition. What you'll find with this is it really relates to the defendant's conduct, and that's consistent with how it's understood in the States, and it's consistent with how it's been applied elsewhere in the common law world, like Canada and New Zealand. It's not, as I said, recognised in the UK specifically, and what I mean by that is it's not recognised as a standalone tort. The way the UK courts have approached it is they'll consider the intrusion as an aspect of whether or not there's a reasonable expectation of privacy, and also they look at it in terms of damages and maybe in relation to other relief like an injunction or something along those lines. But as a standalone tort, you won't find reference to it in the UK. You will find reference to an intrusion as an aspect of damages sometimes in some later cases. The quintessential cases that looked at it outside of the States would be C in Holland from 2012 in New Zealand. Some of you might be familiar with that case already. but it's in global terms, it related to a 25-year-old girl who was videoed in the shower without her knowing about it. So clearly she had a reasonable expectation of privacy, but more importantly for this tort, she was in her seclusion. She thought she was having a shower in private. As it happens, there was a camera recording her. There was no publication. And so with most of the cases involving intrusion, there's no publication as such. It's just an intrusion. And how do you compensate for that? Typically, damages are quite low in relation to this aspect of things. But with respect to the media, it will obviously be subsumed by the misuse tort, which I'll come on to in a minute. And then there's Jones and Sigay, which is the Ontario Court of Appeal case, which dealt with the defendant accessing financial records from the bank at which she worked, just to obtain some specific financial information about her colleague. That was again considered to be an intrusion into seclusion under the common law, and so the Ontario Court of Appeal developed this specific tort in 2012, the same year as in Holland. Most recently, it was referred to again by the Ontario Supreme Court. That was in the case of Stewart and Dem. In actual fact, this case is quite interesting for another reason, in that it was it didn't surmount the threshold of seriousness because the defendant was a drug addict nurse, and so what she did was she accessed a range of medical information about specific people in the hospital that were being treated. And it was very fleeting. And so whilst on the one hand, you might think that's quite striking, it's an intrusion into seclusion. It was so fleeting that the court considered it to be pretty trivial in the circumstances and didn't want to open the floodgates, and referred to some British authority which reflected this level of seriousness. Other than those three cases, you won't find very much about intrusion in Canada or in New Zealand. There might be a handful of other cases which have referred to these, but predominantly you find it in the States, which is not uniformly applied, but generally speaking, it's quite prevalent in, don't hold me to this, but I think about 30 states, and specifically in California, which is unsurprising, where there's a plethora of celebrity that live there. So that's the first element with intrusion into seclusion. The second aspect of the sub-element, I suppose, of the first aspect of the tort is misuse of information. That is set out again in the Act in terms of a specific definition. It's not an exhaustive list, but what you'll note from the slide behind me is that there has to be some positive act on behalf of the defendant. So there's the collection, the using, and the disclosing of information. That's a positive act on behalf of the defendant. And so in the UK, there have been a handful of cases which have picked up on that positivity or the positive conduct. One good example is the case of DSG, which involved hackers. So the defendant was sued for essentially permitting having engaged in negligent conduct, essentially, but allowing hackers to obtain information from its systems. What the High Court there said was that this isn't a case of misuse of information, because the defendant hasn't engaged in any positive act. There still has to be a use, even with respect of misuse. And so even allowing or having a system which allowed hackers to gain access to information wasn't enough to get them across the line in terms of the tort. And given the fact that the Australian version of this is obviously a serious invasion of privacy, it has to be an intentional tort. It would be consistent with that line of authority, at least as it currently is understood. Then, do you want me to go on to the second element? The second element being reasonable expectation of privacy. This is given a specific definition in section 7.5 of the schedule. I've underlined in red here some important aspects which have proved to be quite decisive in the United Kingdom on this topic. In particular, the attributes of a plaintiff, the age, occupation, cultural background can be quite important, but arguably the more important of these is with respect to 5F and the Roman numerals 1 to 3. So that is the nature of the information, how the information was held or communicated, and whether and to what extent the information was already in the public domain. There's just a word of warning that comes with this aspect of things. It's substantially the same as the UK approach. There's a well-known case of Murray and Express newspapers in 2008, which essentially say what Section 7.5 now says. So one has to have that in mind when construing the section. However, the caution comes with the fact that most of the authorities that flow on from it are all led by the Human Rights Act. Now, under the Human Rights Act, that actually brings into force the European Convention of Human Rights, and under Section 2 and Section 6 of the Human Rights Act, courts are compelled to act in accordance with the European Convention and consider Strasbourg jurisprudence. There's nothing like that in Australia. And so just bear that in mind when looking at the case law involving construing the section, but also involving the way that the UK courts have gone about solving this particular issue of whether or not there's a reasonable expectation of privacy. That said, of course, clearly these cases are bound to be illustrative to a certain extent.
Well, shall we move on to talking about competing interests?
Sure.
So, I mean, central to sort of liability for this cause of action will be the balancing of competing interests. So, what are the sorts of interests that have to be balanced, and how do you think that this is likely to work in practice?
So I'll fast forward to this slide. So on the one hand, obviously, there's going to be a reasonable expectation of privacy, and on the other, there's going to be this countervailing interest, and the countervailing interests are given specific definitions within the Act. They include, I'm not going to go through them all, but they include some obvious ones, which is freedom of expression, freedom of the media, and open justice, as well as national security. There are about 3 others. And so one has to balance, and as a media lawyer, we hate the word balance, privacy on the one hand and these countervailing rights on the other. This has only been done in the UK. It's not done in the States. It's not done in Canada or even in New Zealand, as far as I'm aware, but I might stand corrected on that. But it is very much done in the United Kingdom. And the way that the United Kingdom goes about this issue is obviously led by Strasbourg and led by the European Convention. So what they do is they start from the proposition of having equality amongst the competing interests. No one interest is greater than the other, and it's very fact specific. There's no hard and fast rules with respect to how to go about looking at the balancing exercise. It has been called the ultimate balancing exercise by Lady Justice Hale, she of famous brooch fame, and that's been uphill and down dale throughout the UK, and surprisingly, seeing as it was said on the Supreme Court. But the relevant case for that is a case called Ries A. Child. It's now quite an old case, but it's still good law in the UK. And I suspect that when it comes to how an Australian court will construe this section, they will engage in a very similar exercise, despite the fact that it's been led by the European Convention and Strasbourg.
So that's a really great sort of overview of the elements. Does anyone else want to amplify, or is there any sort of comments from any of the other panelists about aspects of the elements?
I was going to ask how those 2 elements of the 2 aspects of the first element interact, the notion of seclusion and misuse of information, where you've got someone intruding into someone's seclusion, but there's also an active publication. how do you think that's going to operate? Is the intrusion aspect just subsumed into the misuse element of the tort, do you think?
I think it would be a very rare case where it's just purely about intrusion into seclusion. It would be a C in Holland kind of example where there is that just purely the intrusion and no publication. If there's going to be a media case, and we'll come on to the media exemption and things in due course, so it might militate what I'm about to say, but it's conceivable that it would be both an intrusion and also a misuse all at the same time. And that's the way, in some respects, the UK's gone about it, albeit using a different vehicle to get there. But I can imagine that the two would be, or other intrusion would be subsumed by the misuse. I don't know whether you have a different view to that.
No, I think that's, and I mean, the legislation clearly contemplates it could be either or both.
Yeah.
So. All right, so an unusual feature about this cause of action is that, unlike most other sort of common law jurisdictions, this is a creature of statute rather than the evolution of judge-made law. So that means, of course, that there may be some interesting issues, difficult issues of statutory interpretation, particularly in circumstances where cause of action is in a schedule to a long-standing pre-existing act. So, Amanda, I wonder what you think about the sort of issues of statutory interpretation that we might encounter with this new tort.
Yeah, thanks, David. I think there are going to be, I see three main issues arising in the construction of Schedule 2. The first is the one you've just referred to. What do we make of the fact that this statutory tort is contained in a schedule to an act that's been in operation since 1988 and brings with it, therefore, a whole body of case law already about what the terms mean in that act? So a good example is the word collection, which appears in several parts of Schedule 2, particularly the journalist exemption and collection of information. Collection is, of course, the subject of some Australian privacy principles in Schedule 1 to the Privacy Act, and there's a whole lot of case law about what collection means in that context. Now, ordinarily, that would be the fact that they inserted this tort as a schedule to the Privacy Act would be highly relevant to the interpretation of the terms in Schedule 2, but because there is a presumption that the legislature intends that words used in an act are intended to mean the same where they're used in that act. But like all presumptions, that is subject to rebuttal by contrary intention, and Parliament has made its intention crystal clear in this Act that none of the case law around the terms of the rest of the Act are intended to have any bearing on the interpretation of Schedule 2. So you can see this in Clause 6, Subclause 2 of Schedule 2, which actually says that in determining the meaning of an expression used in this schedule, Schedule 2, an expression used in the rest of the Act is to be disregarded. Okay, it doesn't get any clearer than that, unless you look at Subclause 3. In case it's not clear enough, in determining the meaning of a provision of this schedule, the rest of this Act is to be disregarded. Okay, so they really have done all they can to rebut that presumption, which means, good news for lawyers who aren't familiar with the Australian privacy principles, you don't need to get across all that case about what collection means in the Privacy Act. It also goes the other way, by the way. So they've inserted this, I think it's section 94X or something to the Privacy Act, which says in construing the rest of this Act, an expression in Schedule 2 is to be disregarded. Okay, so there is no doubt that this is intended to be an entirely standalone tort, a statutory tort, if you like, which of course begs the question, why insert it as a schedule to an existing Act in the first place? And this did come up in one of the Senate reports, but and they didn't answer it, but I suspect it's simply that if anyone's going to go looking for a cause of action for breach of privacy, they're going to look in the Privacy Act, so let's just put it there. And anyway, sometimes, lest I be too glib, sometimes Schedule 2 does say this meaning has the meaning that it has in the rest of the Act. So courts and tribunal orders is one example. When you look in Clause 6 of Schedule 2, courts and tribunal orders has the same meaning as in the Privacy Act. And there's other examples. Australian law has the same meaning. Agency has the same meaning, which could have relevance to the ABC. So there are times where they have explicitly said, yes, they mean the same, but otherwise you can disregard the rest of the Privacy Act. The second statutory construction issue that I see on the horizon is one that Matt's already referred to. What's the likely relevance of the UK case law and the other international case law, the American case law, Canadian, New Zealand, in interpreting the words and expressions in Schedule 2? There are ways in which that case law can become relevant to determining the meaning of words and expressions used in an Australian Act. When construing an Act, we're looking at the text, the words used, read in their full context, where those words appear in the Act, which division. So it appears in the division about X, or does that colour what those words mean when used in that division? So the text in context, read against the purpose that for which Parliament, acted. What mischief were they trying to remedy when they passed this law or passed this provision? Now, the best indication of purpose, as the courts are always saying, is the text that's actually used. Sometimes the text won't get you very far. And, if anyone's a bit of a nerd like me, you love digging through the extrinsic materials about what's the story behind this Act? What was Parliament actually, thinking when they did it? Matt, can you just, brilliant, you've already done it. What I've collected for you there, I don't know if you want to take a screenshot or a photo of what's on the slide. As many of you would know, Section 15AB of the Acts Interpretation Act refers to certain extrinsic materials you can have regard to. It's not limiting, but it turns out in this particular Act, this really covers it. So, explanatory memoranda, second reading speeches, other parliamentary debates. So I've collected the website where you can get all of those legislative materials, like the Senate reports, are in the first link. Another piece of material, extrinsic material that you can have regard to are various reports that were tabled before Parliament, before the Act was passed. So I've got there the two Australian law reform reports the explanatory memorandum explicitly says this is why we've done this. We've done it to implement these recommendations of the Law Reform Commission. So you'll find some really interesting guidance in those reports. Other extrinsic materials that the Acts Interpretation Act refers to are treaties, which I'm going to come to, and as I said, the explanatory memoranda. And those of you familiar with explanatory memoranda will know that sometimes they can be particularly unuseful, because all they do is restate what the section says. The explanatory memoranda for this Act, it's like they wrote it knowing they want this to be looked at by the courts. This was written for courts to look at because it's replete with, it is intended that blah, it is intended that X, it is intended. And one of the things that it says it's intended to do, and here's I'm looking at, if anyone ever wants to look it up, paragraph 358 of the explanatory memorandum, the statutory tort for serious invasion of privacy is intended to operate similarly to other torts developed through jurisprudence. They're expecting the courts to work this out. Parliament hasn't intended to be prescriptive. They're letting the courts do that. And when the courts do that, you can have further in that paragraph 358, it's intended that courts will draw on key concepts from other torts, including privacy torts in other jurisdictions. So there's a clear message to us there that, yes, a lot of this case law could potentially be relevant. Paragraph 415 of the EM explicitly makes reference to the House of Lords decision in Naomi Campbell's case, even though it mistakenly refers to the English and Wales High Court citation, but that what they were meaning to refer to is the House of Lords decision, where say that the Balancing Act that Matt was just talking about is similar to that identified in Campbell's case. So they clearly had this case law in mind when they wrote those different things to balance in the Balancing Act. And if you've read the House of Lords decision in Campbell's case, you'll know that a lot of them draw on Chief Justice Gleeson in Lena Game Meets. So maybe we've actually got more jurisprudence than we think. Some of them liked it, some of them didn't. But keeping on the potential influence of the UK, and this is something Matt mentioned as well, there is that European Convention on Human Rights background to a lot of the case law in the UK. They have the Human Rights Act, which makes that, that convention part of their law. Essentially, we don't have that in Australia, as Matt said. So what you'll need to be careful of when you're looking through these international cases and the UK cases in particular is how much of what the court said is derivative of the language in the convention, because the convention doesn't have any application here. So, the courts are going to be very wary, and they are very wary. We've seen this in a case recently of importing anything from foreign jurisdictions that's based on that jurisdiction's domestic law. So there may be a limit to how much assistance Australian courts can actually get from a lot of the overseas cases, to the extent that it's based on conventions that just don't apply here. But that doesn't mean that there are no international sources that are relevant. And this brings me to the third potentially big issue that I see arising here, which is that Clause 4 of Schedule 2 makes clear that the entire tort is relying for its constitutional validity on this being a law made pursuant to the external affairs power in Section 5129 of the Constitution. And so the words they say, oh, is that a ding ding? It's time for you to stop. Stop talking. It explicitly says it's relying on the power to make laws, specifically to give effect to Australia's obligations under the International Convention on Civil and Political Rights. So the purpose of Schedule 2 is to give effect to at least part of the ICCPR. And it's a recognised presumption of statutory construction that legislation is intended to be consistent with Australia's international obligations. And this presumption is particularly strong where the purpose of the Act is to give effect to Australia's international obligations. So, and really that is what clause Schedule 2 is seeking to do, to give effect to these provisions of the ICCPR. And again, in your explanatory memorandum, Clause 13 explicitly sets out the articles of the ICCPR that this Act engages with. So Article 17, the right to privacy. Sorry, I'm with Dad on this privacy. The right of freedom of expression in 19 sub 2. Freedom of conscience, thought and religion in Article 18. Right to security of the person in Article 9. So these are all articles of the ICCPR that are reflected in some way and balanced in some way. Parliament is trying to balance when it creates this tort. It makes clear that while the tort's intended to carry into effect Article 17 about the right to privacy, it's not absolute and it needs to be balanced against freedom of expression and the other rights in the ICCPR. And now, my plug for this is the most useful book in the history of time, in law at least, Interpretation by Hertzfeld and Prince has an excellent section in Chapter 10 about, how to construe acts that are intended to give effect to treaties. And so that is all going to be very useful when we come to interpreting the terms, because Parliament has explicitly said we're trying to give effect to this treaty. So that's a far clearer textual link to rely on for interpretation than things in the EM about UK, etc. case law. So have a look at that. It talks about the Vienna Convention on Law Treaties, understanding treaties. And interestingly, one of the key kind of underlying principles of that is it's intended that countries that implement these treaties will have a consistent interpretation. So suddenly that could potentially bring in case law from other countries that have tried to bring into their law Article 17 of the ICCPR. To the extent that the language they've used is similar to what Australia used, that's a whole other potential source of law there. And as I said, there's a stronger textual link for that in the actual Act because it refers to the ICCPR than potentially in the other, in the UK or New Zealand, or certainly the UK, which relies on the ECHR. So before you go straight and only kind of the UK cases, just consider how are the terms of the European Convention different or similar to the terms of the ICCPR in the part of the part of the Act that you're looking at? Given Parliament's intention to carry into effect provisions of the ICCPR, how have those provisions been construed in other countries? And are those constructions consistent with the language, the text that Parliament has used in our Act? Because remember, the Australian courts are always going to go first to the text that Parliament has used here before it goes to any other overseas sources. So they're the three big issues I see on the horizon, and I see lots of scope for debate in the courts about that, lots of scope for disagreement. We saw the High Court disagree just a couple of weeks ago about something everyone thought was settled, the importation of structured proportionality from Germany. You've still got judges saying, well, I don't think we have to do it all the time. So, we can expect a lot of judicial back and forth about all of those issues, except the first, which Parliament has no need to know anything about the rest of the Privacy Act.
Excellent. Well, I should foreshadow I'm going to misuse my chair's prerogative and ask him a question in question time what your favourite difficult issue of statutory interpretation is, because I definitely have a favourite. So you're all warned. So exemptions, defences. There are a number of exemptions and defences under the tort that we've created. Part 3 particularly creates a range of exemptions. I think the one that has been discussed by a lot of people, particularly on the panel in this room, is the journalist exemption. So, Tim, do you want to talk to us about what the provisions are relating to the journalist exemption And how do you see that exemption being working in practice?
Well, the journalism exemption is really an outlier there. There's no guidance on how it's going to operate, so we're all going to just have to make it up as we go along. It's not something that features in the UK provisions or the jurisprudence that's developed there. It's rather incorporated as part of the balancing exercise where the courts there consider the role of the press in the stage 2 test there about freedom of expression and the press being the watchdog or the bloodhound or whatever other animal they describe it as. And it's interesting because in the ALRC report 123, the one at the bottom there, this issue about some of the stakeholders that were responding to that inquiry actually said we think there should be an express exemption for journalists. And in the context of that report, the report said, well, we think that the fault element that Matt mentioned at the beginning, plus the public interest component as part of the elements of establishing the cause of action, provides enough protection in the law for the media. And so it's interesting that notwithstanding that observation in the report, this is a provision that's been incorporated into the statutory tort. It's potentially a very wide exemption, and it applies to both those two types of breaches: the invasion into seclusion and the intrusion into seclusion and the misuse of private information. And picking up on Amanda's point about let's have a look at the memorandum to understand exactly what the rationale is. The memorandum says the exemption is there as part of the recognition of the importance and the benefit of the role of journalism to a free and democratic state or something noble like that, and the prospect that a privacy action could cause a chilling effect to the media. So that's the rationale in the memorandum for the instigation of the provision. A couple of general observations about the exemption. When you look at the provisions in clause 15, section 15 of part 3 of schedule 2, the provision seems to be being directed more at legacy or traditional media rather than new media, social media, journalism, because it refers to the provisions applying to people who are professional journalists, subject to professional codes of practice and things like that. So these are notions of sort of traditional print media journalists or TV journalism. So that's an interesting aspect of how the exemption might work in practice. The second observation I'd make as a general point is, at least on my interpretation, it doesn't provide, and I'm sure other people have different views on this, but it doesn't provide protection to sources, journalist sources. It's directed to the journalists and publishers who publish or distribute the work of journalists. But it doesn't seem to protect or give an exemption to the source that gave the information to the journalist. Sources may be able to rely on the public interest element of the cause of action, so that they still may have that protection. And I think as a practical consideration, if someone's going to sue for a breach of or an invasion of privacy, it's probably more likely to be directed at the media organisation or the journalist rather than the source in any event, because they're the ones speaking in a media context that are publishing the information to the world at large and causing the damage. I think from a practical point of view, it's going to be directed at the journalist or media organisation anyway. But it's just an interesting, and as I say, people may have different views about that. Another interesting aspect about the exemptions generally, but also this one, is that clause 15, 8A, I think it is, provides a mechanism for the early determination of whether the exemption applies. And so again, people who practice in defamation law will be familiar with it. It's almost identical word for word, the provision in the Defamation Act as to the early determination of serious harm. So there's a similar provision that uses the same language that allows the question of whether, in this case, the journalism exemption applies to be determined before a trial. So it's a potential way of knocking out actions at an early stage. And again, there's the same provisions unless special circumstances exist that the issue should await trial. So that's an interesting section that applies to this particular provision. So the clause itself, it's under Part 3 of the exemptions section, and it's headed journalists, etc., which is a bit alarming. I just sat there and thought, well, this definitely has something to do with journalists, but there's also some other stuff, so let's just call it journalists, etc. So it's called journalists, etc. In terms of who may benefit and who the exemption applies to, there are two categories of person, if you like. Clause 15.1 provides that Schedule 2 does not apply to an invasion of privacy by 4 categories of persons. So the first is a journalist, and that notion of journalist is important because it's defined later on in the section. An employer of or a person engaging a journalist, a person assisting a journalist who is employed or engaged by the journalist's employer, a person assisting a journalist in the person's professional capacity. Now that last category, a person assisting a journalist in the person's professional capacity, could apply to a source, but it doesn't really work, because I'm not sure the source would be assisting in a professional capacity. So I think, sorry, I should say, it's those people, to the extent that the invasion of privacy involves the collection, preparation for, or publication of journalistic material. So the two kind of key concepts that come out of that exemption are the notion of being a journalist or assisting a journalist in the collection and publication of journalistic material, and journalistic material is defined in the Act. And so the notion of a journalist is fairly straightforward. I'll come on to what that means. The other categories of people that are included, again, going to the supplementary explanatory memorandum, Amanda? Yeah, supplementary. It's really intended to include freelance journalists who are working for other journalist organisations. That's what it's meant to include. The second category of people that benefit from the exemption is set out in 15.1a, and it provides that Section 2 does not apply to an invasion of privacy to the extent that the invasion of privacy involves the publication or distribution of journalistic material, there's that phrase again, that was prepared for publication by a journalist. And the intention of that category is really to provide a broader protection to people, media organisations, publishers who publish journalistic material and facilitate journalism. That's the idea behind it. So you've got the journalists themselves, the people collecting and publishing the information, and then people who publish the journalist's work are covered by the exemption. And I think, going back to what I said before, I think that when you look at that section, it's really being targeted at traditional media again, rather than social media publishers or similar. So let's have a look at this notion of journalist. Journalist is defined under clause 15.2 as a person who, first of all, works in a professional capacity as a journalist, and second of all, is subject to standards of professional conduct or a code of practice. And that definition actually reflects the definition that's referred to in the Privacy Act elsewhere under media organisations, but Amanda says we're not allowed to look at that one, so we'll just focus on this one.
You can, I'm just saying, you've got to be district.
But basically, a journalist is going to include a reporter, an editor, a producer, or some other person who prepares material for publication. And again, it's talking about someone who's acting in a professional capacity, so it's not necessarily going to include influencers or citizen journalists or someone like that. The requirement to be subject to a professional code or code of practice is something that's picked up in relation to other provisions in the Privacy Act about the handling of information, but the kind of things that we're thinking about are, with the ABC and SBS, they're subject to codes of practice with oversight by ACMA. There's the Australian Press Council that covers print and online publishing. There's the Media, Entertainment and Arts Alliance, which is as you probably know, is the union for people who work in creative industries, and they publish a code of conduct code of ethics for journalists. So you can become a member of that organisation and get various benefits, and you have to adhere to the code. And then some media organisations, like The Guardian, for example, have their own internal editorial codes of practice. So those are the kinds of things that they're talking about when they talk about being subject to a code. Interestingly, clause 15.4 provides that if a journalist does invade someone's privacy, it doesn't matter whether the invasion of privacy actually breached the code or not. And at first you think, well, that's a bit weird, but the idea behind it is to preserve the self-regulatory nature of these codes. So what the court is looking at is a simple objective question: was this journalist subject to the code? That's all they're asking. If so, tick, move on. They're not going a step further and inquiring as to whether their conduct breached the particular code, because they say that's up to the people who come up with the code, and they don't want to encroach on that self-regulatory process. And then, as I said before, the explanatory memorandum talks about people who are non-professional journalists, so people who don't satisfy that definition, still potentially being covered by the public interest element that Matt talked about before. Now, perhaps the most interesting aspect of this journalist exemption is the definition of journalistic material, and that's set out in clause 15.3. And journalistic material is a material that has, defined as material that has the character of news, current affairs, or a documentary, or consists of commentary or opinion or analysis of news, current affairs, or documentary, or consists of editorial content regarding news, current affairs, or documentary. And what's interesting, I think, about this section is how this notion of some material having the character of news is going to be interpreted by the courts, because there isn't any guidance about that. Other people might be corrected if I'm wrong, but when you think about the notion of what is news, it's potentially very, very broad. I mean, the dictionary is pretty unhelpful. It just defines news as a report of recent events. Well, okay, that's not pretty helpful. So on one view, there's this subjective approach that the court could take that will apply a very, very, very broad notion of news. I think that perhaps one approach that might happen is that there is effectively a spectrum or a scale in this concept where you might have a story that concerns exposing criminal wrongdoing or hypocrisy, which will comfortably satisfy that definition of something having a character of news. And on the other end, you'll get something that's a bit like, we were calling it tittle-tattle earlier. I don't know whether that translates, or whether that's a very English expression, but something about, a celebrity doing something or going about their business. And so there's this potential scale of information that's published that might easily satisfy that definition of something having a character of news, and then something that may be a bit borderline or not, and then everything else in between. For example, like a satirical or a satire or something about news, and so I can see the courts perhaps struggling with that notion. And then I think within those concepts, there is perhaps some degree of nuance where you might have a story with a photograph, and the story might contain information that intrudes on privacy, and the photograph itself might separately do that. And the court might say, well, as they did in Naomi Campbell's case, well, the story is in the public interest or is newsworthy because it exposes whatever hypocrisy or some sort of wrongdoing, but the use of a photograph was unnecessary. So, for example, another example is that some terrorist attack or something, and the report of that, and then the use of photographs of victims of that attack might go too far and might be considered to fall outside of the character of news. I don't think the court will take that approach, but it's possible given the way that the issue of privacy has been addressed in the UK. So that aspect, I think, is an interesting one, and I think it's sort of watch this space because we don't really have much guidance about how that will be interpreted and applied by the courts.
I've got a question for you, if that's all right, Mr. Moderator. In the definition of a journalist, as being someone who either is subject to standards of professional conduct that apply to journalists or a code of practice that applies to journalists, what do you think about the fact that there is no prescription as to the adequacy of the code or the content of that code or the origin of that code? How do you think that'll play out?
Well, I think it comes back to the point I was saying before, which is the court's trying to strike this balance between allowing the media to self-regulate and trusting that the media will come up with codes that are satisfactory, and having something that defines a journalist, gives that person a particular characteristic to enjoy the exemption and protection that we get. So I think that's the answer. I just sort of leave it up to put the trust in the various bodies that monitor these codes.
The only comment I'd make on that is the relevant definition is a journalist, and a journalist who works in a professional capacity. And one can contemplate that there are people who might call themselves self-styled journalists and may earn revenue from subscription revenue or from sponsorship revenue or otherwise, and might, for their own personal benefit, many interns or employees that they decide to hire for their blog or otherwise, create a code to say these are the standards that must apply. David, what do you think will happen in an instance where, say, a social media operator who thrives off
your own code.
Of subscription income does their own code, says it applies to me, will they be the subject of an exemption?
Well, I mean, there's the incentive there to do that, isn't there?
But what's interesting is there's no description of the content of what that code would be.
I'm just looking at, because I'm always hung up on the text.
Yeah.
Subject to professional standards of professional conduct that apply to journalists.
That's what I'm thinking.
Or to journalists.
Yeah, exactly. Not
to this journalist.
Yeah.
But to journalists, which does give perhaps a textual indication that they meant something a bit broader. Yeah. However, I can still see a situation where someone might do exactly what Dauid has said, that applies to journalists. So while journalists there is a bit of a textual indicator, I can see there's still going to be gradations where you could get, this does apply to journalists. It applies to the journalists that I have employed in my blog. Which gets you, and it's all circular because you're that kind of journalist. It becomes a bit of a circular.
The ABC code doesn't apply to journalists employed by News Limited.
Right. So, and yet they would be standards of professional conduct that apply to journalists because it does apply to the journalists of the ABC. So actually
Anyway, I just wanted to throw that spanner in the works.
Yeah.
Well, and that's what's your favourite? Sure, statutory interpretation. I'll give you another one if you want one. So, shall we move on to injunctions, which is a disturbing personal obsession of mine, and I know you share this. So, the statutory tort of invasion of privacy creates a really broad injunctive statutory power to grant injunctive relief. So, Dauid, to what extent do you anticipate that this will actually be used? And what do you expect are likely to be the issues that are going to arise at the stage of applying for an injunction?
Well, it's obvious it's obvious to me, having regard to the tort and what its object is, which is to prevent the destruction of whatever interest it is that arises from the protection of private material or a privacy right. I think it is inevitable, but notwithstanding all the exemptions that apply, it's going to be the most powerful tool that will be used by claimants in relation to this tort. It's quite different, and I'll come to this probably a little bit later, but it's quite different from the interest that's protected is an interest which, if it is revealed, some would expect from the objects of the tort is destroyed. And whilst there is certainly provision for compensation in that event, the primary objective is the preservation of that right that has been recognised and the prevention of the wrong, namely the tort, which leads to a intrusion into seclusion on the publication of material that would constitute a serious invasion of privacy. Counterintuitively, of course, there are the exemptions that apply, and the exemptions seem to cover a range of people and interests, including, as Tim's just discussed, the journalist exemption and exemptions in relation to law enforcement bodies and the like. But having regard to the fact that Parliament has assumed that the question of these exemptions is ripe for separate determination, much in the same way as various elements of the cause of action for defamation ripe for separate determination, where Parliament is telegraphing that those exemptions are going to be maybe the subject of separate determination, you can bet your bottom dollar that they're going to be the subject of applications for interlocutory relief and will arise, notwithstanding the prima facie assumption that if you are seeking to get an injunction to restrain a journalist, there's an exemption that applies. For example, taking the exemptions that apply to law enforcement bodies, that exemption expressly has a carve-out or qualification that to the extent that the body reasonably believes it's reasonably necessary for the performance of its enforcement-related activities. Curiously, that doesn't apply in the defence. It's the question of reasonable belief. So from a claimant's point of view, seeking to restrain a law enforcement body from doing something that constitutes a breach of the elements described in section 7(1)(a) to D, it's inevitable that that will be the subject of some testing at an interlocutory level. Similarly, with the journalist's exemption, I can't really crystal ball gaze as to the ingenuity of the various claimants seeking to restrain articles that might be published by the legacy media. But Tim's already touched on at least two issues that are likely to rise or be ripe for consideration, namely whether or not the person is in fact a journalist, whether or not they're in fact it involves the publication of journalistic material, and of course whether or not the material itself is in fact news or an opinion or documentary, etc. So the interlocutory power is, of course, a power that the courts have always had an inherent power to determine these matters, having regard to principles of equity. But there is an explicit provision that the court may consider and grant interlocutory relief, and subject to consideration of what is expressed in clause 9, subsection 2 of the schedule, which I'll come to in a moment, is in very general terms described as the public interest in the publication of the information. And I think there's something to be, it hasn't been expressed in quite the same terms as the fifth element of the cause of action, which is the countervailing balancing action, the balancing element between the prescribed public interest that we all know about, justice, freedom of media, freedom of expression, freedom of law enforcement for detection of crime and fraud, etc., etc. It's just expressed in terms of the public interest in the publication of the information, which must be the information question. So these, I expect that the preliminary issues in relation to the availability of exemptions will arise not at a separate trial level, but will arise and be the subject of challenge earlier on. at a interlocutory level as opposed to as a separate trial issue, because I expect there'll be fertile ground for controversy. It would be remarkable if those very ingenious lawyers who tend to advance these cases for applicants do not challenge whether or not the information has the character of news, current affairs, or documentary at an interlocutory stage. I expect the power to grant interlocutory relief will be well utilised and tested. At least it'll be the subject of some testing and in some early cases, I expect. It may well be that there are some matters that aren't well ventilated, but certainly I expect the journalist's exemption to be well ventilated at an interlocutory level. And as to whether or not, having regard to the principles in ABC and O'Neill, the development of a prima facie case that the exemption may not apply, that will be an important aspect in terms of the exercise of the injunctive power. Obviously, an applicant for interlocutory relief will need to demonstrate a prima facie case in respect of each of the 5 elements. Now, in doing that, they need to demonstrate the objective seriousness of the invasion, potentially evidence of the subjective knowledge of the defendant, given the fact that it's an intentional recklessness is an element of it. They'll need to satisfy the existence of a prima facie case at an interlocutory stage. And they will have to establish at an interlocutory stage the countervailing balancing exercise to say there is at least a prima facie case that the right to privacy will weigh against the countervailing features that have been identified and that the court has to consider exclusively but not exhaustively. And if they can demonstrate that there's a good arguable case, a prima facie case, that the public interest right exceeds those the private right exceeds those public interests, then that's their injunction. Is there anything more I can add about that? I expect it's going to be well utilised.
Out of interest, have you got a view as to which court's going to be hearing these? Because in accordance with the section, I think we'll move this back, the jurisdictions conferred on primarily the Federal Circuit and Family Court of Australia, otherwise affectionately known as the Focaccia Court, Division 2, and also on state courts as well as federal courts. Now, you mentioned inherent power. That's probably going to be an important aspect of it. But have you got a view on?
I expect, for a variety of reasons, including the development of jurisprudence on this, I expect that applications will be going to the Federal Court and to the Supreme Court. I expect.
About costs, because doesn't the Federal Circuit Court operate under that scale of costs for general federal matters? So a plaintiff might go, oh, my cost exposure is lower if I go to the... I don't know whether that's going to be enough to take them out of the...
Then you've got geographical issues with with that court, haven't you? Because it doesn't extend...
Federal Circuit Court?
Yeah.
What do you mean?
It doesn't have extra territorial power.
Oh, okay. So you mean if something's happened that you want to rely
outside of Australia?
Oh, well, but one of the things that this carves out is that the section that gives the Privacy Act extraterritorial operation doesn't apply to Schedule 2 because they specifically wanted to limit it to Australia, things that happen in Australia. So that might not be as relevant a consideration as it would otherwise be. So, because you're right, the inferior court probably wouldn't have that. But that's one of the things in many aspects of Schedule 2 have amended the privacy order to say this section doesn't apply to Schedule 2 and extraterritorial operation is one of them. So I don't know whether that'll affect the court.
I think the short answer to the question which court is going to be informed by who the applicants for these are. If there is a desire, for example, with a well-heeled applicant to obtain some form of superior court guidance on how these questions are going to be analysed, they're going to take advantage of that. the federal court or the Supreme Court would be appropriate courts for that. It may well be those with other cost imperatives will be not so much seeking to make law, but seeking to get what they want at a cheaper rate.
So, Dad, do you want to venture an opinion on one of the most difficult, I think, issues, which is the overlap between defamation and privacy and the impact that that might have on injunctions? Because, of course, this is a very big issue in the United Kingdom about whether bonard impairment can withstand misuse of private information in particular.
Well, I was just going to throw this back to you, David, but I won't.
How long have you got?
But I won't. Look, for those who aren't in the cognoscenti on the rule in bonard impairment, I mean, the rule in bonard impairment is a rule which was accepted as, to an extent, as being part of the law by the majority in ABC and O'Neill, and it operates to bar the granting of injunctions in defamation cases in all but exceptional cases. And there are exceptional cases. There are cases where defamation injunctions have been granted, but the ratio of it is that there is, firstly, defamation is compensable by an order for damages. That's the first thing. If the right that is being protected is your right to a good reputation, and that can be compensated, and you can be vindicated by a judgment and award of damages. And against the possibility that a defendant may have one of a myriad defences that might possibly be successful, it is important that the right of freedom of expression is maintained so that it isn't compromised by the grant of injunction in relation to a defamation that may well be defensible. It places the factors of freedom of expression, it elevates it to a position that does not overwhelm the fact that I'll withdraw that, not doesn't overwhelm. It recognises that the right of a freedom of expression is so important that where there is a compensable cause of action, which may well be defensible, that should be left to final trial. And the way it was described in ABC and O'Neill was as organising principles for the grant of an interlocutory relief. And those organising principles, when one has regard to them, prevents the grant of injunctive relief in a defamation case, except in exceptional circumstances, because the public interest, as it was described in ABC, the public interest in free speech is of considerable relevance when considering the balance of convenience. Now, that is, when dealing with privacy, one's dealing with, of course, an entirely different tort. And I said earlier on, one is dealing with something that is, in substance, destroyed once the cat is out of the bag. When one is defamed, one can be compensated and vindicated and given a solation for that tort. But the revelation of private information, if it is a serious invasion, is something that is hard to compensate. Now, the way in which the Act has dealt with it is by providing, as I said before, that under clause, firstly it's the power, but under clause 9.2 of Schedule 2, the court has to have regard to the public interest in the publication of the information. And should say, there's explained in the memorandum, says nothing to really shed any particular light on that. Yes, the publication of the information. So, if one looks at the context of interlocutory relief and how an application of that kind is likely to progress, a plaintiff is going to be leading a plaintiff or an applicant is going to be leading evidence as to the countervailing public interest and why his or her private interest outweighs the countervailing interests described in 7.3. So what different task might be undertaken by the court in considering the public interest in the publication of the information? How do those two intersect? Well, they're not identical and they're not identically described or defined. So I tend to think that's something to be worked out, but it may well be that they're the same thing. I don't know. It's very, very hard to say. One thing I can say is it's clear that there is regard to be had to public interests, and that's made quite clear and perhaps distinguishes the way Australian courts will deal with it from the English courts, which also consider a range of personal and private interests that concern third parties, other interests of the plaintiff, other than the right to privacy. Having regard to the fact that a range of public interests are likely to be raised as part of the establishment of the prima facie case, it seems clear that there's just going to be an overlap between the two. I cannot see on the language of the Act, and in particular subsection 2 of clause, or subclause 2 of clause 9, how the rule in Bonnard and Perryman, which tends to start from a presumption as opposed to engage in a true balancing exercise, could continue to have application of the grant of injunctions in Australia. That rule seems to be adapted to the tort of defamation, and I cannot see how it can operate with the same force to restrain serious invasions of privacy, or in applications to restrain serious invasions of privacy. I mean, the experience in the United Kingdom and the case decided there, obviously demonstrate the engagement in a true balancing act, and that is certainly the objective of the legislation, that there will be a true balancing act. So I can't see the rule in Bonnard and Perryman having great application.
It depends on the case, though, wouldn't it? I mean, there might be sort of like there are a couple of cases in the UK that spring to mind where someone tries to shoehorn reputational damage into misuse of private information, and is using that as a vehicle to injunct a media defendant, when really it's a defamation case masquerading as a misuse case. And there's like one case that brings to mind, like Spellman and Express newspapers, where I think it was a 17-year-old international sportsman who played rugby or something for England, and his mum happened to be a very well-known MP, and he was accused of using performance-enhancing drugs in the context of his rugby career, and of course his mum and other members of the family wanted to suppress that information immediately because, God forbid, he actually did something controversial, and he used the misuse tort to try and suppress that information, and the High Court rejected it and said this is really a defamation case, and in that context they did look at Bonnard and Perryman. Now, that's not going to be every case, admittedly, and I think I agree entirely with what Dauid said, but there will be cases, I think, where you might find a defamation tort maybe masquerading as a serious invasion of privacy, where that might become more relevant. Who knows? It's anyone's guess.
I just think that the primacy of what is recognised in Bonnard and Perryman isn't. It can't, on the statutory language, have application. It must be a true balancing act between, on the one hand, the right to privacy, and on the other hand, all the various other issues that of public interest that need to be considered. It really is a balancing act.
So before we go to some questions, we've mentioned the overlap between defamation and privacy. So Monique, this is not the only cause of action. There are other sort of causes of action that can overlap or conflict with privacy. So what do you envisage might be some of the problems about privacy overlapping or even conflicting with those other sources? And how do you think judges and practitioners should go about addressing those?
Thank you. So I think there are some problems, but I think the biggest takeaway that I had from doing the comparison exercise was just to be mindful of the differences and that there are some real opportunities to be made with the introduction of the new tort, and just by being mindful of the risks and opportunities that the privacy tort might give to the client when you get a factual scenario where it might arise. So there are various privacy adjacent causes of action. That's just a term I've invented. Some relate in some way to private information, or they're causes of action which just tend to arise simultaneously where there's an allegation of a breach of privacy. So these are defamation, breach of confidence, and I think certain state and Commonwealth criminal offences. The overlap between defamation and privacy is apparent. For example, a media publication which includes private details about someone's life, which are true, but which also includes insinuation and defamatory imputations, or perhaps a work email accidentally published by HR, which includes another employee's private information, but also includes allegations, defamatory allegations of wrongdoing. So there you'll have instances where you have both defamation and privacy considerations potentially arise. There are some clear similarities, which are they both protect personal interests. They both have to do with the protection of intangible interests of the individual. But one of the critical differences is that privacy is protecting the misuse of private information, whereas defamation is protecting someone's reputation. They are directed at totally different kinds of harm. So I think that's really important when you're looking at a factual scenario to ask yourself, it feels like privacy and possibly defamation arise. What's the actual harm that my client has suffered here? Another key similarity is that both of them have non-economic loss as one of the key remedies. So both torts allow for hurt to feelings in defamation or for emotional distress in privacy. Obviously, it's likely that factually very similar kinds of harm are going to be covered by those descriptions. Both of them are also capped at the same monetary value. I will say one issue that I anticipate is going to be an issue of conflict is the question of double recovery, where you do have an overlapping factual scenario and you have a single publication that gives rise to both defamation and a breach of privacy. Are you able to obtain the entire cap under both causes of action or just one? I mean, the general principle is you can't double recover for the same wrong, but in the court, I expect, is going to approach this in one of a number of ways. It's either going to address it holistically. Alternatively, it's a real prompt when you're pleading to make sure you plead the causes of action and the harm very specifically to try and reserve your right to be able to say, I want to plead the maximum cap under both causes of action. So it's looking for those opportunities, I think, when you get a matter. Both of them deal with and have regard to public interest, and that I'm very conscious of the time, it's 2 to 7, so I won't go into that in any degree of detail. But for example, if you had a media outlet that was reporting private but true information, the outlet might invoke public interest considerations in relation to both torts through though the privacy tort focuses on the invasion's seriousness, while defamation is going to focus on falsity and reputational harm. And you're also going to have in relation to privacy the journalistic exemption that Tim mentioned. One of the other key areas of overlap is both of them are going to potentially be able to protect publications. However, privacy torts misuse of private information limb addresses not just publication, but also collection and misuse. So it's broader in that respect, and therefore it might be more useful. Intrusion into seclusion, likewise, you don't necessarily need publication. By contrast, obviously, defamation centres on publication. So if no publication, then no defamation. One thing I would say, just looking at the different, or the similarities, I should say, between defamation and privacy, they both form part of a statutory framework which is seeking to make uniform law. So hopefully that's going to make things more simple as the case law starts to come out, that there's a more uniform approach in the different jurisdictions. Turning then to some of the differences though, as I said, they deal with fundamentally different functions of harm. You've got a requirement of falsity and defamation, which you don't have in privacy. So privacy is going to protect true information, whereas defamation is only capable of protecting false information. You've also got different fault thresholds. So privacy requires intentional or reckless conduct. Obviously, you don't have that in defamation. So if you get a factual matrix where there's an unintentional publication, even if it might otherwise sort of have other factors where you think, oh, this might be an invasion of privacy, you need to have that fault threshold available to prove. There's also the damage requirement. So obviously in privacy, there is no requirement of actual damage, and that's explicit in the tort. Whereas in defamation, with the more recent amendments, there's obviously a requirement of proof of serious harm. So again, if there's a disclosure, but it's quite difficult to prove that there has been actual serious harm to your client or sort of any actual damage, privacy might present an opportunity where you don't have to do that. And so that's just the obvious easiest course to go down. Limitation periods is another issue. Obviously in defamation, you've got 1 year, and yes, there is the ability to extend, but under privacy, you've got between 1 and 3 years. So that's another opportunity where if you get a factual matrix where both seem to arise, but you're out of time, privacy might just present an easier option to go down. I might just jump down just to speak briefly about the comparison with breach of confidence. So breach of confidence has obviously long been used to protect confidential information, but it has a key limitation, and that is the information that has been disclosed has to have the requisite quality of confidence and has to be disclosed usually within a confidential context, like a confidential relationship. That is not necessary in privacy. And just like the tort of privacy, breach of confidence protects information which is true, but unlike breach of confidence, the privacy tort does not require the protected information to be shared in confidence. So if a stranger intercepts your private messages and shares them online, breach of confidence is unlikely to apply, but now the tort of privacy probably will present a cause of action. I will say breach of confidence, I think, remains, on one view, you might say, well, privacy, you don't have to demonstrate quality of confidence, you don't have to demonstrate the necessary confidential context. Perhaps that's an easier cause of action. But I think where you've got a clear trust-based relationship and the confidential nature of the information is well established, it may well be a much easier cause of action than the tort of privacy, where there's multiple elements. You need intentional or recklessness involved in the element of the tort. So just being mindful of, as I say, all of the factors that might arise. As for remedies, breach of confidence has available to it an ambit of equitable remedies, such as equitable compensation, declarations, account of profits. So too does the tort of privacy. But privacy also has available to it an order for an apology, also an order for a correction. And so if these remedies are important to your client, then looking at privacy rather than a breach of confidence is something that it might be useful. Again, just jumping, I'm so conscious of time, sorry, I'm going to skip through, but so interaction with criminal offences, there are some privacy invasive offences, criminal offences such as Division 15C of the Crimes Act, which is recording and or distributing intimate images without consent. Also, all the surveillance devices legislation, Commonwealth and state. And there's Section 477.1 of the Criminal Code, which has got an analogous 308H of the Crimes Act, which basically makes it an offence to cause unauthorised access, modification or impairment of data held in a computer or electronic communication to or from a computer. Those are fine, but the obvious problems with those is that the criminal law doesn't offer compensation to victims. So although previously it might have been quite difficult to have brought a civil cause of action in relation to the distribution of intimate images, albeit there is still own proper pets, but it might have been quite difficult. There's now a much easier cause of action to deal with that, and that is privacy. So I know that was a very brief run through, but I think when you're choosing between the legal actions, ask yourself the nature of the harm, is the information true, what's the relationship between the parties, are there criminal offences involved, what are the remedies that I want to seek. Looking through all of those items, I think the privacy tort just presents some real opportunities to, bring multiple claims.
Excellent. All right, I know we've got a little over time, but we have had questions via Slido, so I'll might throw one or two at least, and not sort of go beyond sort of 7:10, hopefully. But one of the questions that was asked was, will this tort widen the gates for commencing class actions for a tort of invasion of privacy?
Yes. Mind you, in the UK, there's been, I think in the Court of Appeal, there was some concern that it wasn't apposite for class actions. I do think, given the fact that there is it's a statutory creation of a tort, I think it is completely open for class actions. Fertile ground.
All right, so how do you foresee this tort being used against foreign unknown hackers?
I'm not sure whether it will be used against foreign hackers. Like I said before, there would have to be. I mean, putting aside the difficulties of identifying a foreign hacker these days, there's a professional that can comprise a professional outfit. There has to be some intentional use, which ordinarily one would expect the cause of action to be brought against an innocent defendant, essentially, who's been hacked, and that's not going to cover that eventuality. The extent that I think Amanda touched on this earlier on as well, that the Act is specifically located in Australia, so if there are foreign hackers, it's not going to have any role at all.
But the tort will be committed
in Australia.
If the tort's committed in Australia, will, but so it depends what they're doing and what constitutes the misuse of information or the intrusion exclusion, where that happens. The intrusion exclusion, which is presumably happen in Australia. But I can see a misuse perhaps actually occurring overseas, and then maybe this wouldn't catch it. But
Might happen in the
so it
cloud.
depends where that positive act kind of occurs.
In the cloud.
Well, then you've got a real question, don't you? Because it's that.
And if you do get up, the court can order the hackers to apologise. Don't forget that.
So another question was, do you think that the news, current affairs and documentary test may lead courts in Australia to import a sort of newsworthiness standard?
Yeah, I think there's a real risk for so many. I think there's a real risk of that as well. That's what I was getting at before. It's such a nebulous concept and test, and there's no real guidance. And I think there is there might be a natural inclination to import a public interest concept into the notion of news. Is this? It's not just newsworthy because it's something that people might want to know. It has to contain some revelation, some public benefit.
And the statement, the statement that's sort of been made in the English cases that just because it's of interest to the public doesn't mean it's of public interest, and just because the public want to read about it doesn't mean they should read about it.
It's a very, very interesting question, and probably I could go on for about an hour about this topic, but it's really going to reveal, I think, a clash of culture. Because what you've got on the one hand the UK courts that have gone about this issue with, and I'm paraphrasing, but there's basically gradations of publications, right? So you've got at the very top something that's worthy of protection. Let's say political speech, right? We can all agree on that. And then at the very bottom, what the House of Lords said was tittle tattle on the bottom. So what Lady Justice Hale says is, going out to pick up some milk or something is that worthy of news, right? And so she says that's not worth protecting when you look at political speech. So that's the UK approach, bearing in mind that it's been formed by European jurisprudence. On the other side of the coin, you've got what's happened in the States, which is this element of newsworthiness. Now, interestingly, the two Prosser torts, newsworthiness protects one and not the other, right? So intrusion into seclusion, newsworthiness isn't a defence. However, over here, we've got the exemption for journalism. So that takes the Prosser tort to a whole different level. And then you've got the courts, primarily in California, where they construe the Californian Civil Code in a way which is very hands-off with respect to editorializing content. And so there is a very broad scope given to the media over there. So it includes amusement, it includes enlightenment. So that's a completely different cultural environment to the UK approach. And it's the American approach which has actually found favour in some of the other jurisdictions. And it's a question of where Australia falls on this. And dare I refer to what our Prime Minister said the other day of progressive patriotism, where, you know, it could be one of those cases of borrowing from different jurisdictions and then creating an Australian, quintessentially Australian tort. It's a really interesting question.
David, I think we've reached that time.
Yes, well, I was going to answer self-indulgently the question that was directed to me.
Oh, well,
Damages.
Well, no, well, David Rolph mentioned having a favourite clause that he hates. What is it? It's the damages clause, which is the most illogically drafted piece of legislation and requires you to know quite a bit about the assessment of damages for defamation and for privacy and all of the sorts of aggravated damages and the distinction between aggravated damages and exemplary damages. And some people tried to assist the Parliament in redrafting that. We made some nice suggestions, and while they took our suggestions about the injunction point, they didn't redraft anything about the damages point, and so it's still will, I think, prove fertile ground for problems, but you can read about that later.
Have you got a view just quickly on the quantum of damages?
Well, yes.
The likely quantum of damages?
Well,
because traditionally in the UK it's really low.
Yes. And that's, I think, because for a long period of time, it emerged out of the cause of action for breach of confidence and then metamorphosed in a way that would never happen in this jurisdiction into a tort. And so I think the sort of restraints that they had on the vindicatory aspect of an award of general damages, the aversion to having exemplary damages, which you see in Justice Eadie's judgment in Moseley and News Group newspapers, those sorts of things I think will slowly sort of move away in the United Kingdom. And so you have seen from the sort of very low initial awards of Naomi Campbell and even someone like Max Moseley, comparatively those look quite low, you see a sort of steady increase in those sorts of damages. And I think that, you know, if someone has had their privacy invaded, then a component of an award of general damages would have to be to vindicate the fact that their privacy has been invaded. And, you know, just to touch on one of the doctrinal issues, in the legislation it clearly says that you can't award aggravated damages. The reason for that, of course, which you would have to explain to someone, is that if it's got a fault standard, it's not a tort of strict liability, it requires intentional or reckless conduct, then you assume fairly properly that the conduct of the tortfeasor is improper, unjustifiable, or otherwise lacking in bona fides. So what you actually need to say is you don't need to award aggravated damages or a separate head of damages. But yes, the sequence is illogical. I think in the UK we're starting to see a sort of uptick as you should.
As a result of the settlements from the phone hacking.
Yes, yes.
I think it's time we wrap this up before we lose too much more attention. I think the takeaway message is there's an enormous amount to be unpacked by the courts, and we encourage you all to litigate. And can I thank everyone for attending online. Thank our panellists for their careful input into all the various features of this discussion. And that's all.